pass all their rights and come and just fire him. Why do we have to recognize any rights? Because it's moot now. We fired him. Well, the process, the purpose of the due process is to ensure the integrity of the investigation.
I guess my point is, I'm not contending or suggesting in any way that all of the officers, your clients or any officer's rights, would be disregarded or not considered, or that such an officer would not be entitled to substantive or procedural due process, but only that if there is a particular right to a fair investigation that is ongoing now, and to a right to have an unfair investigator removed, and if there is no investigation ongoing now and no unfair investigator is existing right now because there's no investigation, I'm still wondering why that particular procedural due process right has either been violated or not. But we can't, that toothpaste is out of the tube.
But it's not, Your Honor, because that investigation, which they have completed, albeit unlawfully, is going to be used here in a personnel board hearing to discharge Captain Gardner. That's the product of the unlawful investigation. It's not over. They have to and will use that in a personnel board hearing. So what they do is they get the opportunity, they fire them. They're not going to have the opportunity to determine whether his rights were, and not just related to investigators, but other matters which are brief. And then we'll use that in a personnel board. And that's the reason they tell you we need more time. The whole purpose of that is to get more time, so the personnel board, the time frame has to run. Captain Gardner will have to defend himself. They'll use this investigation, all of the fruits, regardless of how they got it, whatever they violated, against him. And then, if he can't defend himself, he has no due process to challenge the investigative technique, then he really has no remedy at that point. See, that's the difference between the investigation in their minds is over. You're fired. But we know, because he has rights to it.
The statute doesn't say that based on the compliance review panel's findings or recommendations that evidence be disregarded, thrown out, not considered by the...
No, you're right, correct. It doesn't.
It just says you remove the investigator.
No, but the findings that there was violations that relate to things other than the investigator can be used at a personnel board hearing.
Whether or not we have a review panel or not, and regardless of the review panel's findings. It doesn't say anything about disregarding the investigator's determinations, findings, or evidence uncovered, allegedly uncovered by the investigator.
But the findings of those that compliance review committee can go beyond removing investigators.
But doesn't necessarily.
It doesn't have to. But the argument is that it does. And that changes the validity of the investigation. Because without that enforcement, that procedural due process right, you cannot challenge the integrity of the investigation. They effectively can deny any officer any of the rights under the statute.
Well, I don't know why you can't challenge it. I don't understand that. Why you couldn't, in a subsequent proceeding, to determine whether or not this was a valid and appropriate and proper and legal termination, you couldn't go back and show the bias and all the rest of it.
Because the personnel board is not charged with making those determinations. The compliance review committee is the only entity that is charged with making those determinations. They are specifically prescribed in the statute to make those findings. Personnel board, we're talking about other issues where they don't have the authority to make those findings. So we only have one party, and it's a very limited review board, and it's a very specific request who can hear these matters and adjudicate those issues and make determinations and remove investigators if they deem it appropriate.
Where does it say that the review panel can direct that some evidence that was turned up and relied upon to terminate an officer can't be considered? Where does it say that they have that authority?
Your Honor, it
just says they report to the agency head who removes the investigator. It doesn't say, and then the agency head can't consider anything the investigator had found or any evidence the investigator had provided. It doesn't say anything like that.
The presumption, Your Honor, is that if they find something, these are a panel, is that Again, we can't control what the agency may do. The agency may fire him anyhow, so we don't care about any of your rights. We just don't care. We can't control that portion of it. All we can do is have that hearing with the belief that that compliance review committee will hear the matters and will make a fair adjudication after hearing the evidence and present that to the agency head.
Who will remove the investigator?
May remove the investigator, may not.
But there is no investigation. There's no investigator anymore.
There are, but there are
No, there was. There isn't now.
Well, that we'll see as we move forward. But nevertheless, the findings of that compliance review committee goes not only to investigators but to other aspects of the agency. They may not be able to remove those people. For instance, it talks about, as Mr. Caney talked about, the requirement to have a internal affairs investigative report completed prior to a notice of intent being issued for the officer. That's a requirement. It's a procedural requirement. And of course, in this particular case, that didn't occur in relation to his notice of dismissal. That's a finding by the compliance review committee determined that was an intentional and done intentionally.
Well, then it may mean that that his notice of termination or termination is invalid, but you didn't ask me to undo any of that. You asked me to order them to impanel a compliance review panel. That's what you asked me to do.
That's
to
correct.
make sure, as I understand the statutory scheme, that there is no ongoing investigation by an investigator who is intentionally violating the requirements.
Right.
And since you conceded that there isn't such an investigation ongoing, it seems like it would be a futile act.
Well, Your Honor, for instance, one of the violations that's noted in the written documents that were provided to the county was a notice related to the reopening. As you've heard, this investigation was reopened. The statute's very specific about how you can reopen an investigation. You just don't reopen one because somebody exercised their rights. Compliance Review Committee would have to determine, was that done intentionally? If it was done intentionally in violation, then that's a matter for the agency to determine, and it's also, however it gets applied, it's subject to an 838 examination. That's one issue. Again, there's a list of about a dozen of those violations as we move through this. Persons who continued after demand was made as investigators with the process. So what they did is they continued with their investigators, even though demand was made, even though the requests were made, what they did is use the opportunity to continue with those investigators to ultimately dismiss him.
I guess part of what's concerning me is that it doesn't appear to me that this statute is designed to provide a review and look back to see if everything was done, as the saying goes, according to Hoyle and appropriately. It is a review to make sure that there is no continuing investigation that is being done intentionally, wrongfully, or by a biased investigator or something.
Your Honor, if that's the case, then...
It's not designed to be an after-the-fact review of what went on, is it?
Well, that's a good question. Is it? Because that's the only way you can challenge the investigation. If, in fact, that's the case, Your Honor, all they have to do to defeat any claim in all the cases, all those cases that are in these law books related to the Policeman's Bill of Rights, those cases are over. Those investigations were over.
That sounds like a problem for the legislature.
But in that particular case, Your Honor, they could defeat any claim for a Policeman's Bill of Rights by simply firing the officer before the hearing's held. What about would it matter if we filed this action the day before or day after? Because either way, the investigation's over right now. If they finished it and fired him yesterday, the same argument would be made.
If the compliance review panel, the purpose of it was to provide an investigation, a separate investigation of the investigator and of the process used to determine the facts that were relied upon to discharge an officer, terminate employment of an officer, then your argument would resonate. But if, in fact, this statute is designed to have removed biased investigators, again, I'm using shorthand, who are now investigating an officer, then that's a different issue.
Even if the claim and the notice were all timely made during an investigation